Hello, in this video we are going to talk about agency law and contract liability. Why is it important? Because if you can prove that somebody is an agent of another person, you can go after the principal, right? Because contract liability creates a direct line from the principal to third party. Imagine an agent goes to a dealership and buys something for a principal, for a company or for his boss or somebody else. Then the dealership can directly go after the principal because the person who walked in the door was the agent of that principal. So it is very important to understand agency law and contract liability. Remember, the key is to first realize if there is an authority, and we discussed that in our previous video: express, implied, or apparent authority. If third party can prove any of these three authority, then third party can go after the principal and claim damages, claim contract breach, and all that's related to contract law. For example, let me give you some examples. Paul owns an apartment building and hires Ann as the property manager. Paul tells Ann to hire a landscaping company. Ann does so. Paul is bound to that contract. That's express authority. Okay? Similarly, for implied authority, if Paul makes Ann a general manager of the building and that person goes out and hire a landscaping company, that is implied authority, because implicit in making that person the property manager of that apartment is that that person can hire a landscaping company. So on exam and in real life, you always have to ask, what did the principal authorize? What would be reasonable to carry that authority? And what appearance did the principal create for third parties? And the last question is very important for apparent authority. So the question you might ask yourself is that, well, Professor, third party can always go to the principal if there's an agency. If somebody comes to me and says I'm an agent of another person and wants to transact some items, then if there's a breach of contract, I can go to the principal. However, the question is, can you also sue the agent if, let's say, there is a breach of contract? In that situation, there's only one situation where the agent is not liable. And that is where the agent walks in and says, hey, I am the agent for a principal, and here is the identity of the principal. If the agency is made clear and the identity of the principal is made clear, then the third party cannot go after the agent. So imagine somebody walks in the door and says, I am the agent of the company Google. And here's Google Inc. and here is my agency relationship. So whatever I'm transacting is for Google. That's enough to essentially get the agent, him or herself, out of the equation. So it is very important to understand authority and for the agent to disclose agency law and the principal's identity. Otherwise, the agent, him or herself, may also be on the hook for any breach of contract in this context. Have a great day.